There is a law on the books right now that makes something you did this morning technically illegal. Not in some obscure foreign country. Not in a history textbook. Right here, in the United States. Today, and the wildest part, you've probably done it hundreds of times without a second thought. Most Americans have. In fact, most Americans go their entire lives without ever knowing these laws exist, until the moment they find out the hard way. Before we get into it, just a quick note. I'm not a lawyer, and nothing in this video is legal advice. This is purely for education and information. Laws can vary depending on your state or city. So if something here catches your attention, talk to a qualified attorney about your specific situation. All right, let's get into this, because some of what I'm about to share is genuinely going to stop you mid-scroll. Number one is something almost every single person has done in the last 24 hours. And no, I'm not being dramatic. Here's the scenario. You're singing along to your favorite song while you're making coffee. Maybe you're in the shower. Maybe you're driving with the windows down. Feels completely innocent, right? Pure joy, zero harm to anyone. But here's what most people don't realize. Under copyright law, the rights to a song don't just cover selling it or streaming it. They extend to public performance. And the definition of public in American law is far broader than most people imagine. It doesn't require a stage. It doesn't require an audience. It can include places where the public has access. Now, in practice, nobody is getting dragged into court for singing in the shower. The law isn't typically enforced that way. But businesses, restaurants, barbershops, small gyms, they've been hit with lawsuits for playing the radio without the right, licensing agreement, some of them for tens of thousands of dollars. The law is real. The enforcement is real. And most small business owners have no idea it applies to them until they receive a letter from a licensing organization they've never heard of. That's the trap. The law isn't hiding, but nobody told you it was there. And that theme, laws that nobody told you about, runs through everything we're going to cover today. Let's talk about something that affects almost anyone who owns a home, rents an apartment, or has ever collected rainwater in a bucket. Because in several states across the United States, doing exactly that, collecting rainwater, has been restricted or outright illegal, depending on how you do it and how much you collect. You might think that sounds insane. Water falls from the sky. You put a barrel under your gutter. How is that anyone's business? Here's why it exists, and it's actually more layered than you'd expect. In many Western states, water rights are governed by a legal doctrine called prior appropriation. Basically, the first person who claimed a water source, a river, a stream, a water table, owns the rights to a certain amount of that water. When rain falls on your property and runs off into the ground, it can legally be considered part of that downstream water supply that someone else already has rights to. So by capturing it, you're technically intercepting water that belongs legally to someone downstream. Some states have loosened these laws significantly in recent years. Others still have real restrictions on volume and use. The point isn't that you're about to get arrested for a rain barrel. The point is that in America, even the water that falls from the sky can be subject to legal ownership claims. And if you're planning off-grid living, a homestead or sustainable landscaping at scale, not knowing this could cost you real money in fines and legal fees. The people who learn this lesson late usually learn it expensively. Speaking of things that sound harmless until they're not, let's talk about your car, specifically what you're legally allowed to do in it while it's parked. This one surprises people every time, and it varies significantly by state and municipality. In several jurisdictions, sleeping in your vehicle, even on private property, even on your own property in some cases, can be treated as a violation of vagrancy laws, anti-camping ordinances, or local vehicle habitation laws. Cities have passed these laws with increasing frequency over the last decade, and they don't just apply to people experiencing homelessness. They apply to anyone. Road trippers who pull over to rest, truck drivers, college students sleeping in their car between classes, people who just don't want to drive home tired. Now here's the deeper problem. The enforcement of these laws is wildly inconsistent. One officer might knock on your window and move you along. Another might issue a citation. In some cities, repeated violations can create a legal record that follows you. And because these ordinances are local, city by city, county by county, you can cross a state line, pull over in a new town, do exactly what you did the night before, and find yourself in an entirely different legal situation. Most people find out these laws exist while they're sitting in a parking lot at 2 in the morning trying to explain themselves. Don't be that person. Now we're going to go somewhere that genuinely shocks people. Because this next one doesn't just affect what you do, it affects what you say. Most Americans know about the First Amendment. Free speech. Protected, right? And yes, it is a powerful protection. But it has limits that most people dramatically misunderstand. One of the most misunderstood is what's known as disorderly conduct or disturbing the eye, peace. These laws exist in every single state, and they are written broadly enough that heated verbal arguments in public, even ones that don't involve threats, even ones that don't turn physical, have resulted in arrests and criminal records.